If your business is failing, do you have the right to fire an employee you can't afford to keep on? Not necessarily, according to the Ontario Human Rights Tribunal. That's my subject on today's Fiamengo file. I'm Janice Fiamengo of the University of Ottawa. In my last video, I talked about the human rights tribunals that operate in Canadian provinces which decide cases of alleged discrimination under the Human Rights Code. These tribunals were originally supposed to be a quick and cheap way for people who had been discriminated against in housing and employment to find resolution. But the tribunals quickly became Orwellian means of social control in which extremely trivial and ambiguous cases of alleged wrongdoing are adjudicated by social justice warriors keen to detect and punish even the subtlest forms of bias in Canadian society. For this video, I chose two rulings, more or less at random, to give you a flavor of how the tribunal implements its agenda. Some years ago, Ezra Levant wrote a book called Shakedown: How Our Government is Undermining Democracy in the Name of Human Rights, in which he examined some outrageous cases, including his own. I'm going to focus instead on ordinary cases, the everyday happenings at the tribunal where people are found guilty of all manner of prejudice and made to pay for their sins. In the first case I'm going to look at, the respondent was guilty, in my opinion, of a trivial form of discrimination and was given an extremely harsh penalty. In the second case, the respondent was not clearly guilty of anything at all, but was still punished. Now, I'm not a lawyer, as you know, so I invite you to look up the cases yourselves and tell me if I'm wrong. First case. In a 2010 judgment, an unwary Toronto landlord who didn't even show up for the hearing, whether because he knew he was doomed or because he didn't understand the significance of it, was found to have contravened the Human Rights Code when he refused to show a bachelor apartment to a 47-year-old man who wanted to rent it. He said he thought the apartment was too small for the man and more appropriate for a young female student. So it's hard to dispute that he did discriminate against the man, though in a manner that happens nearly every day, I suspect, as landlords make quick judgments about who looks like a desirable tenant. His error was in being honest about it. I found it very hard to believe the complainant's testimony, which was that he, quote, felt very hurt, broken, and alone, end quote, as a result. Disappointed, okay, yeah, really annoyed, sure, but broken seems a step too far. In the ruling, we're told the incident was, quote, a true affront to his dignity and that, quote, for a long time afterwards, he didn't feel up to searching for another apartment and ended up staying in his basement apartment as a result, end quote. Well, if true, this is surely an overreaction. But the Commission accepted and even magnified the complainant's sense of injury, reporting that the harm was, in feminist lingo, intersectional in nature, i.e. it was a double discrimination based on sex and age. I must admit I'm somewhat surprised that a white man of 47 years old would be considered a victim at all, according to a feminist intersectional victim schema. But the irony is staggering. Canada is a society in which white men are regularly discriminated against in hiring, for example, by government mandate. The same government that's now so worried about one white man's feelings. The difference is that government-mandated discrimination is not, as here, a one-time incident. It's a systemic bias, and moreover, it's one applauded by respectable society. But that's the way it is in Canada. It's okay when the state does the discriminating, and it's not okay when it's one individual landlord making a choice of tenant. In this case, the landlord was likely a Greek immigrant to Canada who may have known little or nothing about our human rights legislation. His name was Panaitis Michlades. For his act of discrimination, Michaelides was ordered to set things right with a whopping $5,000 plus interest payment to the complainant. And he also had to pay out of his own pocket for a human rights expert to draft a statement about the Human Rights Code for him to post in his apartment building. According to the adjudicator, the landlord's offense was made worse by the fact that he was warned by the complainant when they met that it was illegal for him to refuse to rent to him on grounds of age or sex. Apparently, quote, the respondent, the landlord, just walked away and told the complainant he was crazy. So according to the adjudicator, the, quote, callous and blatant nature of the respondent's discriminatory actions exacerbated the injury to the complainant's feelings and dignity, end quote. And that's what led to the relatively high award. Now, the logic seems all wrong. It seems the landlord didn't know anything about the Human Rights Code. He may genuinely have felt that the complainant was too large, as he said, for the small apartment, and that therefore he wouldn't be a long-term tenant. The point is, he genuinely didn't know that what he was told about violating the code was correct. It struck him as crazy, as he said. So this is far more likely a case of ignorance rather than blatant callousness. And I would have thought it might lessen the severity of the offense rather than exacerbate it, but it doesn't. Furthermore, the adjudicator in the ruling seemed to find it necessary not only to punish the landlord for the sin of preferring a different tenant, but also to go on at length about how it wasn't really a punishment at all, but a, quote, remedy. I'll bet Panaitis Michaelides felt it was a punishment. He was fined thousands of dollars for doing what a lot of landlords do in one way or another. Do you think he learned something about equality? Certainly the complainant learned something, that it's profitable to catch somebody out in a crime and pretend to be, quote, broken and alone over it. And for that, taxpayers were billed thousands of dollars. In the second case, the decision is even more startling. This is a 2008 judgment involving a small-town restaurant owner in Geraldton, Ontario, who terminated the employment of one of her waitresses, a friend whom she had herself waitressed with before she started her own restaurant. Now, the waitress claimed that she had been terminated because of discrimination, because her spouse was HIV positive and had hepatitis C, and restaurant patrons didn't like her working at the restaurant. The restaurant owner didn't dispute that some patrons were unhappy, but said she had dismissed the waitress because the restaurant was struggling financially, and she simply couldn't afford to keep her on, not out of any bigotry. The waitress had been the last person hired and therefore was the first person to be let go. There was plenty of evidence of the restaurant's financial problems. There were NSF checks and so on. To complicate matters slightly, the complainant produced a letter by the restaurant owner in which she actually stated that she was firing her because of complaints about her spouse's condition. But the restaurant owner complained that she'd written the letter upon the request of the former employee who wanted to, she said, get back at those who had gossiped about her. It sounds as if she had a lawsuit in mind from the very beginning, and then in the event she decided to go after her former friend. A revealing side issue in the affair concerned the complainant's attempt to pressure a witness to give false testimony about the restaurant owner in return, she promised, for a share in the damage award that she was seeking. The adjudicator actually found that the complainant lied to the tribunal, tried to mislead the tribunal. But still, drum roll please, still found that the restaurant owner had contravened the Human Rights Code. According to the adjudicator, if any part of the decision to fire the former employee had to do with her spouse's HIV status, then that is enough to constitute contravention of the Human Rights Code. Here's the statement by the adjudicator, quote, even if there are legitimate reasons for terminating an employee, if one of the factors or considerations was discriminatory, then the termination will be held to be a violation of the code, end quote. That seems a remarkably broad definition of a human rights violation. In the adjudicator's mind, even imminent business failure can't provide justification for an employer's action in firing an employee if grounds for discrimination have been established. He writes as follows, quote, "Businesses are required to comply with the code not only when it is economically advantageous or economically neutral, but even if they feel there is an economic risk or disadvantage. Economic interests and rights do not trump human rights." End quote. But is there a human right to be kept on by a restaurant owner even when the restaurant is failing? The implication is that it's better for the entire restaurant to go out of business and for all the employees to be out of work and, of course, the entrepreneur to be financially ruined. That's better than for there to be even the appearance of discrimination. How good it must feel to the adjudicator with a guaranteed fat salary paid by the state to preach to a struggling small business owner on her moral duty to sacrifice her livelihood on the altar of human rights. As for the complainant, despite being found to have sought to mislead the tribunal by pressuring a witness to give false testimony, no punishment or even serious rebuke was forthcoming for her. So she gets away with lying to a government body in an attempt to get money out of a former employer. The only disappointment for her was that she failed to gain the financial compensation she was seeking. The restaurant owner did not, in the end, have to pay her, but still didn't fare very well. Though not forced to pay damages to the complainant, the adjudicator did mandate that the restaurant owner give $2,500, money she could obviously ill afford, to a local AIDS charity. Why? To show the great moral rectitude of the adjudicator, even though there was no evidence whatsoever that the restaurant owner harbored any prejudice against persons with HIV or was guilty of anything more than wanting to keep her little restaurant afloat. That's the kind of work the Human Rights Tribunal is doing with taxpayers' money, making life difficult for ordinary people in the name of social justice, and in some cases, I would say, creating the very kinds of racial and other animosities that it claims to be curing. So those are the two cases. Tell me if I'm wrong about them. And believe me, there are plenty more every year. It's quite a system we've created in Canada, a forum for powerful elites to demonstrate their moral superiority over the great unwashed, all the while being paid out of the taxes of the same people they're set up to judge. It doesn't inspire confidence.